All right, everyone, let's go ahead and get started with our next panel.
I did not know there would be lights.
I think we should. Yeah. A little brighter.
I didn't do it.
Okay, thank you for joining us for the next panel in the afternoon. We're hoping that this one will actually be very exciting because we have quite a range of folks. We have both innovators who've sold their companies, including to Medtronic and IBM. We have lawyers who are who's a leader in the field, and we also have people from the strategy and acquisition space as well. So I'm going to allow each of our panelists to do a bit of a self-introduction, if you wouldn't mind, and we'll go through so the folks know your background before we hop into questions. Can we start maybe from Rich over?
Sure. So Rich Wesorick, a managing partner of the Tarolli law firm here in town. I was thinking earlier when somebody said managing lawyers, you don't really manage lawyers, but we're maybe managing chaos. I've been practicing for 27 years here in Cleveland, same firm, the bulk of which is doing medical technology protection, and honestly about half our firm works in that space.
That's great, thank you. Charlie.
Hi everybody, I'm Charlie Lougheed. I'm the founder and CEO of a company called Axuall, which was formed back in 2018, along with a number of health systems, some in the area. Got about 26 healthcare organizations that are the customers or partners now. So as you'll hear me talk about, so much of our success has to do with co-innovating with our customers. And it's a little bit of a secret sauce here, I think, in the Midwest. Before that, I co-founded a company called Explorys, along with Cleveland Clinic. That was a really fun experience in healthcare big data, and Axuall is also healthcare big data. But that grew like wildfire, and in 2015, on our way to preparing to go public, IBM made us an offer we couldn't refuse. So we're excited about that, and that flourished thereafter. And part of that, another startup that sold to a public company as well. So IP has been something absolutely critical to our business, not only protecting us, but protecting our customers and our shareholders. So I'm excited to learn a little bit here myself as we get into the topics.
Great. Charu.
Charu Ramanathan. I'm the CEO of Vitalxchange, which is a social network for parents raising children, especially with special needs. Prior to that, I founded Cardio Insight, which was a cardiac mapping company, which was based on my research work at Case Western Reserve University. So I have some experience transferring intellectual property out of the university that I was an inventor on, as well as several instances of in-licensing technology from other entities, but also forging partnership agreements where IP was an important asset. So I'm also eager to have a discussion here on a very important topic that is really the primary asset of most startups for a very, very long time.
Thank you. Todd.
Great. And Todd Schwarzinger, I'm General Manager of Business Development and Licensing for the Cleveland Clinic. Jumped in that role about a year ago. I'm responsible for all the fun technologies coming out of the clinic, trying to find the right partners to license our IP, to take our technologies forward and hopefully get them to patients. That's our main goal. Kind of non-traditional background to licensing. I spent most of my time in finance. I was an investment banker for about a decade, biotech and medical device, most of that time in London and in New York. Working far down the line, M&A, IPOs, and kind of I saw the need and the excitement of IP driving most of the companies I was working with there. I've progressively worked my way earlier and earlier as I've worked through my career. Was in venture capital for the last 5 years, and now I'm about as early as you can get on the innovation cycle. So excited. I'm still learning a bunch on the licensing side, so excited to learn some from this panel as well. But great to see everybody.
Hi, everybody. I'm Mary Kander. I'm a senior consultant with Wave Strategy. Wave Strategy is a consulting firm that focuses on commercialization and acceleration of healthcare technology, all early stage. Our primary client base includes large academic medical centers, universities, biotech accelerators, and actually startup companies. And so I've been doing that for about since the beginning of the year. And before that, I was at Cleveland Clinic Innovations, and I was responsible for the group, the technology commercialization group, and that's the group that was basically doing all the licensing of the clinic technologies.
Okay, thank you for that background, everyone. And just to start with our company founders, because I think that'll be some of the most interesting bits of information here is how has intellectual property affected your company's growth? And maybe we can start with Charu and then go to Charlie.
Yeah, so with Cardio Insight, obviously the core of the company was formed by a technology transfer agreement with the university. So we had technology that was developed at Case Western Reserve University that we had to transfer out, and then we built on top of it, and there were derivative patents, so we had to decide whether it was invented as a derivative of the Case technology or else it was more original to our engineers and our R&D team. So that's one aspect of it. The other aspect of it is we did a lot of clinical research agreements with 15 centers worldwide, and intellectual property was a key subject because we would do the studies, we would discover something, then who owns what, and that sort of thing. And when it came to the acquisition of Cardio Insight by Medtronic, all of these things, we spent a ton of time cleaning everything up, making sure everything was assigned, because one thing about IP is if the inventorship is challenged, then it becomes invalidated. So there's a lot of intricacies around intellectual property, and ultimately in medical devices, the IP it has to be extremely strong with very good freedom to operate for what it's worth, because that is what a very large company is acquiring at its core, because they're building a lot around it. So when we started Cardio Insight, we had 3 patents, and when 8 years later, when Medtronic acquired, we had over 35 patents built on that core portfolio. So that's kind of blood. It's in our blood, so to speak. No pun intended.
Charlie?
Yeah, IP has always been central to almost every business that I've been involved with since I was a teenager. And it's funny because we stumbled across some pretty interesting things along the way. We've a company founded back in 1999. It's called Everstream. It is not the same Everstream. There's another Everstream now, not to confuse anybody. But and at the time, we were developing streaming media technology. And first, we went out there and tried to understand: is there a need in the space for this? Can it be advertising led, or can it be subscription based? There wasn't much appetite for subscription. There wasn't much bandwidth to push this stuff, and but there were a number of competitors that were out there, kind of vying to be the first technology. One of them went under. Was about to, and we went and visited them, and we were thinking of just acquiring some other people, and they. He says to me, well, we have this patent. It just recently got filed, and we had another one that was filed quite a while ago, and it just recently got issued. I'm like, okay, and all right. So and we started thinking that, okay, maybe we just acquire the company, not just the people. So I asked, well, what does the patent do? It aligns a listener or a viewer of an on-demand video with an advertisement based on something that says this ad's for them. At the time we were just looking at it going, okay, we brought that founder in. It was a really good relationship. But the key there, and the same things with Cleveland Clinic, and the same things with University Hospital, and all the companies, is you got to figure out a way. We let them know how important it was. I think some people looked at us and said, "Are you crazy? Why are you telling them how valuable this could be?" But he was important to the design of the technology, and we just wanted to bring him into the fold. And I just find that a lot of times you can argue a lot about IP. I think sometimes you get to the point of diminishing returns really fast. But at the end of the day, if you treat your co-inventors or your licensors with respect and kindness, you can go a long way, a lot faster. And so, our perspective has always been, you find a real need, find something that's novel around it, develop some IP, put some overalls on that and put it to work.
That's really fascinating because as we heard from Laura and from Ari's presentation as well, it seems that professionalism and having that sense of building community with the people that you're working with, making sure that you're doing right by the people that you're working with, finding a win-win, as Laura said, can lead you to better outcomes. And oftentimes as IP lawyers, we don't really realize that. We're going for attack mode all the time, and that might not be the best outcome. So coming back to this question of how intellectual property has affected your company, I also want to talk to Todd about this as well. What role has intellectual property played for the Cleveland Clinic's growth and success?
Yeah, I mean, it's our sort of currency to some extent. I mean, our organization, we see 200-ish inventions a year that come through our system. And as early as is sensible, we're trying to protect that IP. My entire job is trying to find those inventions, bring them through our development process, and get them to the right partners. And ultimately what that means for us is a lot of our innovations around specific treatments for patients, specific drugs that could have a really meaningful impact on the lives of patients with rare diseases. So in addition to a financial outcome, hopefully, that we're going to get from licensing and finding the right partner, for us, the big focus is impacting care. So finding the right partners that can get it to market and getting into the hands of patients is the big focus for us. But it's what we do every day. So.
That's helpful. So we talked sort of at the high level, but I'm curious, what are specific stories that all of you have? Sometimes we learn lessons the hard way when it comes to practice. What are some stories that you have from your experience of times when you learned the value of intellectual property or a critical lesson about intellectual property in your careers? And I'll start with Rich.
This week?
Right.
This month, maybe today, maybe actually, I'll go with a yesterday. On the phone with a client, came to us, a little over a year ago to work on a project. They have early stage investment. They've got, money behind them. They're getting ready to convert a provisional patent application and just doing some run-of-the-mill searching as part of the conversion, and it's literally being filed today, the conversion. We found a really relevant piece of prior art. So, but it was a situation where the early stage company had an offshore search firm do their work. They kind of got what they paid for, and they detrimentally relied on that. And here they are, kind of sliding into home on converting their patent application, looking to go pound their chest to their investors about how good their IP is. And not only are they maybe not patentable, but they've got serious infringement problems. So I think the takeaway is, spend some time up front really understanding, what the scope of your protection can be. And it's tough. These folks all work in early stage environments with limited budgets. And you don't know how much effort you want to put in up front, but this company in particular is taking on water at a time when they really did not want to, and it could have been prevented earlier with some a little bit more time put in up front.
Interesting. Charlie, what about you? You can just go across.
Yeah, I think one of the things we always do, we have these disciplines with our startups. We, number one, we always have a data room. So for those not familiar with merger deals, a data room is where all the information about the company exists. The IP's in there too. So starting just the process of thinking about, okay, what file folder is this going to go in? It begins to get you thinking. I would tell you that we have found, even if it's expensive in the seed stage, and it is, when you're in the room with your product team and your engineers, make sure someone from an attorney from your IP team is there too. Not because you're going to come up with something perfect out of it, but they are going to have context, and it's like supercharging your lawyer. And for the additional cost that it is, I think it's kind of a wash, because frankly, by the time you write the claims a lot faster, you kind of just bang, this thing just sort of bangs out on the fly. And again, when you got an attorney saying, that's not, I don't see how that's novel, guys, or we're doing some iterative searches along the way, like, don't do it that way. That's too close to what's already out there in this case. It just is really helpful. And it gets the whole, by the way, when you do it early enough in a startup, it gets the organization to start thinking about how important it is. Because we don't want to use the past to go beat somebody over the head with. We want to figure out how do we partner with other larger organizations much bigger than us and have a little bit of leverage along the way.
Interesting. I will add one point about having an attorney in the room can be very helpful, because I can't think of how many cases I've been in where we were able to get through to some critical information, like a scientist saying, gee, I don't think that's novel, and the attorney's not there, so it's not protected by privilege. And then you end up with problems that way. You always want to make sure to have that attorney involved so that you can maintain privilege over some of those discussions as well. Charu.
Yeah, I want to share one good story and one not so good story. So, the two sides of the IP coin, on the other side is the licensing side. Like, you want to take this IP as an asset, you want to bring it into your company, and you want to build a product around it. So when we started Cardio Inside, I had just graduated from PhD and didn't have any real world experience, was an idealist, still am to some extent, but so we wanted to license this, and we were working with attorneys on both sides to really bring this asset into the company. And the university, obviously they built this, they funded it, this was their baby, and I was an inventor on that patent. So I was very abrasive. I said, I'm an inventor on this. It's going to sit on a shelf, so why don't you give it to me? Well, you have no business experience, blah, blah, blah. So they built this very ironclad licensing agreement that would protect the university in case, inexperienced Charu squandered it. And I had just had my baby at that time, so my attitude was, you'll never outweight me. I'm a baby, I'll just sit at home, take care of this baby, and wait for this license. So 18 months and a lot of really terrible meetings later, we finally got the license, because the license had to come in for our funding to come in, and the funding has to come in so that we could bring in our early executive team, and the executive team wouldn't come in without the funding wouldn't come without the IP, and we just sat in this cycle for 18 months, right? Did all of that, we all became really good friends, we know each other's children's names and everything, everybody's happy. 8 years later, Medtronic comes in. They look at it in our data room, and they said, this one, take this up, take this up, take this up, take this up. Done. Don't want any of this stuff. We won't do the deal if all of these control provisions are there. So I'm like, 18 months, $50,000 later, the whole agreement just went to, because there was money to be made and it really didn't matter. So I would say that was a huge lesson learned for me, to really look at the practical side of what both parties are trying to achieve, and not really hang your hat on every single legal term. So that's my bad story. My good story is that the lawyer that worked on the other side was Gary Pitzer out of Tarolli. I loved him. He was a great guy. So since then, for the last 20 years, he's been our patent attorney for 5 of our companies. So the point is, he's always there, always take him on tours to see how we're thinking about things, even we're ideating. And then Gary is like, has anybody done this before? Have you looked into this? Or what about this? So already we have a very rich relationship where your patent counsel is almost like your CTO working alongside, and then is there a there? Every 6 months we're like, is there a there? And finally we just filed our first patent for Vitalxchange. So really like a team approach.
I'm not going to tell him all that good stuff.
His head would get big. Yeah, no.
Stays in this room.
He'll want to raise.
We'll just keep the commercials coming.
Todd,
Yes, mine was actually sort of, again, my experience started in investment banking, so I was exactly on the opposite end of this, on the M&A side. I worked on a number of billion-dollar deals in the biotech space, and all of them were predicated on IP around a specific therapeutic compound or something of that nature. And all of that was predicated on decisions that were made 15 years before, 10 to 15 years before. So I would say the learning from that, and all of that was scrutinized in the M&A process to such a level that it's pretty amazing to think. But I would say the most important thing is getting IP counsel engaged early, quality IP counsel engaged early, because the decisions you're making early will impact down the road. And we're talking about some of these deals that I was working on, the drugs themselves were $1 billion a year in potential revenue. So when you think about licensing, when you think about royalty, when you think about protecting that potential IP, there's a ton of value in small little tweaks and small little changes, and the way that you're protecting that asset, I think, is pretty critical. And those decisions made early are when it all starts.
All right, what about you? Any war stories?
Yeah, so that's actually a good segue about protecting the assets. So I was involved in a pretty lengthy patent litigation a number of years ago. and learned some hard lessons. The main lesson being that the federal courts do not feel obligated at all to provide any deference to claims construction guidelines provided by the USPTO. This was a 101 law of nature situation. Actually got a lot of press, in terms of the response. And so the feedback there was that, or the situation there was that, this is when I was at the Cleveland Clinic, we had patents that we filed. The first round of patents were declared invalid because of laws of nature type issue. In the meantime, the USPTO had put out really very clear, specific guidance on claims construction in terms of getting these natural, it was a biomarker, allowed. And so we filed a patent that actually was approved very quickly because it matched the guidelines. It was almost like the guidelines were written for our biomarker. And so the courts again decided that, hey, I know that you follow these guidelines, and I wish I could remember some of I did used to know the quotes exactly because it was so mind-searing. While we have great admiration for the expertise of the USPTO with respect to patentability, we don't have an obligation to provide deference to their guidelines, and we will rule as we see fit. And so we lost all those cases.
And that is a huge impact on like an entire class of technologies.
Yeah, I think, right, especially on and I remember one of the other comments at that point was, discovery, even though it might be brilliant, groundbreaking, life-saving, it doesn't really matter.
And it's still evolving.
Yeah, so it really impacted biomarkers, biotech diagnostics, and really innovation in that area, knowing that most of it is not protectable.
Yeah. We actually just went over this with my class at our last session of our intellectual property survey class. We were talking about Section 101, patent eligibility, and we walked through some of the history and the fact that so many people had received patents based on the earlier cases and the earlier guidance, and then everything changes. Then people go and get patents based on the new guidelines and the new cases, and then everything changes. And so you have so many fields where people have built businesses around a set of patents that are no longer going to be upheld if they get challenged, which creates a very unique business problem for folks.
But it also really, in the early stages, because we work early stage mostly, it affects investor interest in the technology. And that's kind of one of the biggest outcomes of that.
Do any others have follow-up or experience with how the changes in subject matter eligibility for patents have affected them or the companies they represent? We'll do a little detour and mention that if folks do. No? Okay.
Same issue.
Okay, same story, yeah.
Yeah, I know very well the story Mary's talking about, but along that same line, there was the cases that came down on the diagnostic side, but also on the software algorithm side, and that's really changed. We had the same thing. We had a lot of viable technology that suddenly had invalid patent protection, and then there was a whole wave of, so software's not patentable anymore. People kind of thought that, but lawyers are creative. Patent lawyers are marginally creative. So we figured out ways to, we know how to claim things now. So it's not a true statement that software is not patentable. It's just claimed differently.
And it's hard because if you need to claim it differently in order for it to be a valid patent, you don't necessarily know what you need that to look like according to what the Supreme Court's going to decide 5 years from now.
Yeah, it's a moving target for sure.
Exactly. All right. So circling back to some of the things that we had talked about through our pre-call, I know in addition to these substantive issues, there are unique issues of value in IP in the medtech space. And can anyone tell me a little bit about how they go about trying to decide the value of patents or other intellectual property in the medtech space? I might start with Mary on this and go down this way.
So, I'm not an attorney, but I have worked with a lot of startup companies and also done a lot of licensing. And we talked about this briefly before. I mean, the first thing that any entity needs to do is get trusted, high-quality patent counsel, because most of the people making business decisions for companies, whether it's investments, acquisitions, whatever, are not IP experts. And so that would be the first thing, is that either if you're on the buying side or the receiving side or the selling side, you need to know and understand the quality of your IP, and almost always that means that you need to have an advisor giving you that guidance. And I know, it was brought up before, usually, again, during any kind of transaction, it goes into the data room, and it's the first thing any sophisticated investor or company looking at a transaction is going to have for any technology-based company, is going to have their trusted IP advisor. It's almost one of the first things that people look at when they're evaluating a technology. You might think, oh, it's science, the clinical studies, trials, results. They're all it's as important as the science in terms of moving forward in a transaction.
Yeah, again, it's the currency that we work with. So the importance of protecting it first is critical. So we go through a pretty rigorous process, which I think I'll have a chance to walk through in a little bit, from a development perspective, where we go from idea all the way through to something that's ready to be partnered. But along that way, we're working with IP Council, but we're also doing our best to understand how it fits into the overall kind of ecosystem of the overall technology, landscape for a specific either therapeutic, medical device, or otherwise. So there's a lot of work that goes into understanding those competitive dynamics as we're thinking about who the potential partners are going to be and what the value is going to be in their hands. So there's a lot that goes into it.
Yeah, I don't have any specific comments per se, other than it's much harder to protect specific methods and algorithms to do things than physical parts. So from a valuation standpoint, we really try to look at it, okay, whether or not, how critical is this IP to get the product started, core of the product, or else scalability or first mover advantage or something, and try to bring some business aspects to it. Because software IP is very hard to validate without that piece, just because, a lot of the elements are left as trade secrets, because it's very hard to say, okay, we have an artificial intelligence machine learning. How do you patent that, right? But you have some secret sauce in there, so it's been very challenging lately, especially with software algorithms, to put the right value on it.
That makes sense. Charlie?
Yeah, Krista, I think I'm sort of always thinking about other mergers. Well, first off, getting deals done with customers. Second, any kind of merger that may come down the way, and then, or obviously a full-out acquisition. And we try to be, we're a little difficult to deal with sometimes, I think, because we're pretty hard line. We say, we're going to develop some technology together, the company owns it. Now, you're going to get something in exchange for that, whether it's royalty or whether it's or equity. But we're going into business together, and because otherwise you can run into these situations. And then you've got things like if certain things, the company, aside from like threatening disbarment, but where the company struggles, you still don't want to give up that IP, because your shareholders are now going to be mad, because that's what's left in the liquidation. So you really got to go into it as business partners. It's almost like, okay, we're in this to the end. And I think that's hard for a lot of organizations. It's really hard for, and I know you guys don't do this that much, and I'm so grateful that Cleveland Clinic took a chance on us, and we worked really well together, and that's rare that you have something like that work out so well. And I would say that it's just think about the end game, and make sure that like you said, Charu, just it's got to be clear. It's got to be who owns it, how it gets transferred, because it's important.
Krista, one of the hardest questions we get as patent lawyers is they say, well, tell me what the IP is. And people want that answer in 2 sentences. And we all know as patent lawyers that it really comes down to the scope of the claims. So as you're looking at valuation of IP, it's sort of that same conundrum, because the market kind of speaks on what the value of the IP is. And when you get into analyzing what's in the data room, and opposing counsel, the counsel for the acquiring company or the acquiring investors starts really breaking down the claims in each one of your patent applications and looking at how exclusionary are the claims, that's where you really find out what your valuation is. And I think many people think, well, I've got 15 patents. Doesn't that mean that I've got this huge valuation? No, because 12 of them have ridiculously narrow claims. They don't really provide a lot of value, but maybe these other 3 actually have meaningful exclusionary power. And I think, Mary, you and I can think of at least one acquisition of technology out of Cleveland Clinic where there was a massive group of IP that went into it, and then really 1 or 2 patents that drove the whole business deal because they had the really broad claims.
So Todd, I wanted to touch on, you mentioned that you might be able to explain a little bit about how the Cleveland Clinic acquisition and evaluation process works. I'm sure that would be of interest to many in the audience. Can you tell us a little bit about that?
Yeah, I mean, I kind of mentioned this earlier, but it all starts with an invention idea coming from our clinicians, either from, some of our world-leading surgeons coming up with an innovation on the medical device side and a procedure and treatment of patients, or learner research is our research institute that could potentially be a therapeutic that's identified that potentially has some serious long-term potential as therapy. All starts there. As early as invention disclosure, we're already starting to think about IP. We're starting to think about when we want to engage counsel, and we're starting to identify what our strategy around the IP is going to be, because in the end, that's how we protect the asset. So we've broken our process up into sort of 4 key steps. We have an engagement function, which is we've got a team of about 10 people that spend their entire day working with our inventors. So trying to identify ideas, trying to help them understand what is a protectable idea and what is a novel idea, and to bring those into our system. We go through a really detailed assessment process. We do primary, secondary research. We do a ton of sort of high-level freedom to operate work on the IP. We try to understand the IP landscape. Is there something truly defensible here? Is there something that's going to give us a competitive advantage in the market? And we do all of that work before we even think about spending $1 on developing the technology or pushing it forward. But as we're going through that, the point that we do make a decision to push forward in developing is when we bring counsel on, and that's the first thing that we do in a lot of cases. So we identify it very early on. As we work through development, we're continuing to refine that IP strategy and how we're protecting the assets. And then when it comes to my group, which is sort of the business development end of the function, we've got a really strong IP set of technologies, well-protected set of technologies that we can take to a partner. And for us, as we're looking for partners, and as partners are evaluating the technologies we're bringing to them, the IP discussion is critical. So we're doing a lot of clinical work, generating a ton of clinical data alongside that as well. And there's other novel pieces that go into our development process that create a ton of value as well as we're looking with in dialogue with partners, but the IP really is what drives it there. So we start very early. This is one of the first things we consider.
And I will note, for students, we have on occasion had a couple of students do internships with the Cleveland Clinic. So if that's something that you're interested in being involved in, you should talk to Career Services about that too, because there are sometimes opportunities to do that if that's a space that you're interested in. So there are some very unique ways of operating in Cleveland and unique aspects of being in Cleveland, especially because there are so many high-profile partners to work with in this space. Do any of you have commentary on sort of the unique practice or doing business in Cleveland?
I maybe just start by saying I don't have to raise so much money or as much money as my coastal competitors. Mm-hmm. They go out and raise it's obscene, like 5 times what we raise, because they need that money to just figure it out, from scratch, blindly stumble around. Our secret sauce here in Cleveland has been this community we've had, our anchor institutions. It's been incredibly important, and Explorys and Axuall are not the only examples of that. And so, again, I think you de-risk the investment from an investor standpoint by knowing that you're developing this with a customer that has a really big need, and they have insight to that problem that takes those that are outsiders in the space a decade to figure out sometimes. And so, yeah, I mean, I think especially in healthcare, I literally knew nothing about medicine when Steve and I started Explorys, and but the Cleveland Clinic team and folks at university hospitals and Mercy and other places kind of took us under their wing and taught us this stuff. And within a few years, we're like, oh yeah, we know how to look for certain markers and data, and I mean, we weren't qualified to do that, but we certainly could talk somewhat intelligently about it. We stayed at a Holiday Inn Express or something like that. Yeah, that was my Holiday Express experience. But yeah, I mean, I think that's really noteworthy, and for us, and some of these other competitors that are out there, it's like a few 23-year-olds started a company and they took seemingly a good idea and spun it out of Y Combinator, and there they go. It's like, okay, who are you working with? And that's just so key.
Yeah, I spent 5 years in the Bay Area in the sort of venture capital ecosystem before moving back to Cleveland, and I saw a lot of that money get lit on fire on the West Coast. So there may be a lot of capital, but I would say in terms of healthcare ecosystems, from a clinical perspective, there's very few places that are as strong as Cleveland. I mean, with the Cleveland Clinic, University Hospital, third largest VA in the country, Case Western, Cleveland. I mean, it's just an amazing ecosystem here. And though we may be a little bit short, the present company excluded on entrepreneurs and founders, the ideas here coming out of the clinic and out of UH are pretty fantastic. So from that perspective, the raw materials are pretty amazing here in Cleveland. I can tell you again from experience on the West Coast, they're all clamoring to work with the same people, Stanford, UCSF. They would die to have access to the clinic. It's pretty amazing from the clinical insight perspective. They've got some of the best KOLs in the world, so aren't too many better places to try and build a healthcare company like there, I think.
Anyone else have thoughts on that one? All right, so we have many people in the audience are lawyers that practice in the intellectual property space, and they don't often get to a point where they understand how IP affects business until they get to the partner level or higher up. What advice would you have for lawyers that are earlier in their careers or perhaps don't quite have that business knowledge? What would you tell them about how they can pair intellectual property legal strategy with business strategy? What should they think about?
My advice is charge less.
So,
Next question.
So I think, one thing that's, and we brought it up, so I'll just kind of expand on it again, is that, the IP strategy, especially for an early stage company, is so foundational, and it has to go side by side with the business strategy. And so to me, it's really developing those partnerships and relationships early. So especially if you're, newer, to understand, like, I have to not just be hanging with the lawyer people. I got to know and understand and be able to communicate with the business people.
We're fun too.
And yeah, because we're all working usually towards a transaction, especially in the early stage. And all early stage transactions involve the legal and the business, and develop that relationship early on. I mean, Rich and I have worked together for years, and I think that that from the business side, you need to have your go-to person that you can call, and that's how you can really, by understanding the business side too, you can really develop that relationship.
So maybe, Krista, the charge to the audience that you're speaking to here is, don't confine yourself as a lawyer to only writing claims. Ask the questions, expand your knowledge of what the company is doing or what the technology might be going for. Maybe it's if it's a medical technology, understand the disease state, whatever it takes to expand your knowledge of what will feed the business side of things. And then take the time to want to educate the business people on what's important to you. Because if you're working together as a group, a technology team, a legal team, and a business team, then ultimately that's going to be a successful venture. Mm-hmm.
That's a great point. We see somebody like our keynote, Laura, who had this job of thinking all the time about both that combination of business and legal strategy, but at the early stage, companies don't have a Laura. They have, a founder and an outside counsel perhaps, and that's it, if they're lucky. And so sometimes the outside counsel needs to fill that role of thinking about the business strategy, of saying to the founder, hey, this claim might not be beneficial for you. This claim is too narrow. It's not going to really help you exclude your competitors. So that person's actually serving that key strategic role until the company can get to a place where they can hire a Laura.
I think one comment I'd like to make is for MedTech companies or even companies where everything centers or IPs that keep part, you're really developing a long-term relationship with the team, with the company team. So it's really important that you're really understanding not only what the subject matter of the IP is, but also what the plans of the company are. Is this IP already in the product? Is it going to be productized now? Maybe later on? How many, what other things are coming down the pike? What are you going to do with this? That sort of thing. And it's really important that the IP council's thinking is evolving as the business is evolving, but the vision is also shared, and you're connecting every few months, not just in the context of applying for a patent, also to do that. The other part, going back to the money thing, is it's also an important consideration is to say, hey, I know you want to go, it'll take us, 40 hours to prepare a full-fledged application, but you can do this now, so let's get the date in. So little short-term strategies which conserve cash, but at the same time allows the company to reach maybe not an idealistic endpoint from a patent law perspective, but a good enough endpoint from a business perspective are really important aspects of service delivery side for IT lawyers.
That's really smart. Anyone else have tips or commentary?
I mean, I think along with that, I think of how many times with Rich we've sat and figured out, okay, how do we do this kind of on a budget? And so there are all sorts of, Rich would be one better to describe, but should we file early? Should we file late? I mean, there's benefits, advantages, disadvantages to both that. What countries should we file in? What should we file, PCT and US, or just PCT, depending on the timeline of when we want to get the first office action? So I think that's, I feel like it's my constant thing, but working with an expert in IP to come up with that strategy also affects, how to do it cost effectively.
And there's no one-size-fits-all, Mary, right? So that strategy that you're talking about is going to be different for every project. And part of it depends on, where's the technology development today? Where's it going? How good do we feel about it? I mean, if this is a Texas Hold'em table, are we placing a little bet, or are we going all in? And so I don't think there's a one-size-fits-all. You just have to spend time talking through those things and make a good business decision on when do you put the right amount of resources towards it.
You mentioned...
We literally went through that this morning, and we got our U.S. patent filed, and the Canadian patent came up. If you want to do early examination, and we waited back and forth, and we're like, I'm glad we had that. They asked us a ton of business questions, and all right, let's go for it now. But there was no wrong answer to that. There was a better answer, but
there was a well-reasoned answer after you talked through it.
Uh-huh.
Yeah.
That's interesting. You mentioned the PCT applications as well. That can be pretty costly once you add it up. And for the students, this is an international applications where ultimately you're going to be ending up with individual patents in different countries. How do you make that decision at an early stage? How are you going to balance that business consideration of the budget you have versus the benefit of having that international coverage? What are some of the things to consider?
I mean, I've done a lot. Rich keeps looking at me. It's hard. A lot of it, when I was at Cleveland Clinic, would be based on how strong we thought the IP was. And so if we thought we had some real foundational platform IP, then we might file, and we look at who the potential licensees or the acquirers are. And then, what we'd also do, for example, we had, like Procter & Gamble. Where does Procter & Gamble file their patents? We were in discussions at that point, and it was really interesting to see, especially on the Ford patent, you think it's this huge multinational, they're not filing everywhere. And so that's one of the other strategies. Where's Medtronic filing? Where's, and see if there's, and always the big question was, was earlier before, China. What do you do with China? And so I think you look at what your potential market is, what your potential licensee, where they're looking, and then you make the decision that way. But in general, when it's and those are for big technologies. I don't want to call them, for more specific or technologies that maybe don't have huge potential market, then often you file U.S. only unless you have a licensee. And then then you can drag it out though by filing the PCT, not filing the U.S. Sometimes you do that when you're not really sure what the strategy is, And, because that's another option too, is to say, okay, let's just file PCT, we'll take the bullet up front, we don't have a licensee in place yet, but we think we can get so-and-so and so, these 3 companies interested, let's file the PCT.
Others have views on the way to balance the foreign applications and budget?
Well, I was just say I'm kind of the devil's advocate on foreign filing, and clients come in and they've got this. They've done some market research, and so they've got 12 countries they want to file in, and I say we're not filing in any one of those until you can convince me. And then I start asking them a bunch of questions, and part of it is market and where your competitors and how good are the patent laws there, and and I basically put them through the ringer to convince me that each and every one of these countries outside the U.S. or regions actually makes sense. And you'd be surprised how small that list gets. Mm-hmm. One of the things that I like to remind people too is, if your major market is the U.S. and the U.S. laws prevent somebody from importing that device, then, if there's really no market in Canada, the market's here, you probably don't need a Canadian patent. Let them make it there. It's a very small market there. If it's big here, just let the U.S. patent laws prevent them from bringing it here, and you may be okay. And I said Canada, that's maybe a bad example, but because those are relatively inexpensive patents. But those are just the kinds of ways that I like to push back, because you don't want the IP portfolio to become a liability instead of an asset. And if it's too big and not well spent money, it's a liability.
Yeah. And not only for the cost to get it, but also the maintenance fees.
Absolutely, the whole thing.
What are some of the countries that you think are tend to be the most beneficial after the U.S.?
Well, I think for many technologies, including the medical technologies that we're talking about today, first tier is an EPO filing. Mm-hmm. And after that, I think almost everything else is a second tier consideration, and we'll go from there.
Okay. EPO being the European Patent Office for the students.
Do you agree with that?
Yeah, I was going to say, I agree, because your two big sources of medical companies are U.S. and Europe. And so those typically, once we went on a stage where we thought at one point we need to be filing all these places, and then almost always it just comes back to U.S. and EPO, because that's who your potential acquirers are. Yeah. And the way that we rationalize that is that once the company acquires us, they're going to be developing new IP that they're going to be filing in the other countries that are important to them. And then when we talk with licensees, including big multinationals, they're really not expecting much more than U.S. and EPO. Mm-hmm. They're not expecting India and Australia and Azerbaijan and places like that. They're expecting that most places are only filing U.S. and EPO.
Charu, with Cardio Insight, where else did you file besides the U.S.?
We did, so our biggest markets, obviously, we followed the cardiac patients, mm-hmm. Germany, UK, and then we also did Japan, mm-hmm. which was one of our key markets.
And during the acquisition process, was it important that you had those countries?
Yeah. So going back to the decision, so before we licensed the patent from Case, due to cost considerations, there's no reason to file it all across the country, right? So our core patent was only U.S. Mm-hmm. And so we had to create a deliberate strategy, knowing that our potential acquirer would not like that, would see that as limiting. So we had some other dependent IP that you needed to operate the product that we actually filed worldwide mm-hmm. in all these large mm-hmm. markets. So that's how we circumvented it. But the problem is when you're in an acquisition situation, the company across the table is going to want coverage. I mean, and with cardiology, we know where the biggest cardiac patients are. So we just said, okay, let's just cover those ones.
But that was kind of an evolving foreign filing strategy based on where you were with the company, what the resources were at the
yep.
time,
yep.
and then ultimately dictated by your acquirer.
Yes.
Yeah.
Yes.
Yeah, and we kind of start, I walked through our process, but from invention kind of inclusion in our process, we're starting to think about the commercial potential outcome for this. That includes partners, that includes what markets, what the total addressable market is, to your point, where the key patients are, how you're going to address them. So we're trying to answer those questions early. And I'd say our filing strategy is giving us as much flexibility as we can to optimize the value down the road. So we start combining the IP with the potential commercial outcome, that analysis early on to help us make these decisions.
I will say though, I'm going to come up on this exact decision of no money with Vitalxchange, mm-hmm. just starting to raise our seed capital. But the thing is, our IP is our digital, is our scaling It's our scale strategy because we have human expertise, and then we have all this digital content and tools that we want to blend in, especially we want to launch this globally in Southeast Asian countries, Africa, just because we are a parenting platform. We want to be of value to, people across the globe. So we're going to come up on this decision as to what do we do here, because patent prosecution in those countries is not very strong either. Yeah. But it is our core idea to scale in those countries because they won't be able to pay for the
So those are tough. Those are tough calls.
Yeah.
Really.
Yeah.
That's
We're not
fascinating.
there yet, but Gary's always has an answer.
Well, and that leads to another question, because the strategic plans that a company might have with IP change as it grows. We talked a little bit about a startup that has a very tight budget, but as you continue to grow, you might have additional needs for more protection when you have you're more of a target or you have more competitors that you have to deal with. How do you adjust your strategy as you grow into a more mature company? You can't get those patents back that you chose not to pursue it once you've released that information or published it in another patent somewhere. So what do you do as you grow?
Yeah, I mean, I would say, getting back to have a lawyer in the room, we do every quarter, we do a quarterly product update, and half the morning's on competitors, half the morning, the other half's on customers. We have customers come in and talk, and then we're with the product engineering team in the afternoon, and we've just made it a ritual, and almost always something comes out of that. Well, all right, our lawyers will come back with something a few weeks later and say, here's what I think we should add, or also pursue, or whatever it might be. Now, we're still a little conservative about some of that stuff. We don't go after everything, so we want to feel convinced that it makes sense too. But again, it's expensive and it's hard to do when you're in pre-seed stage. But it doesn't mean you can't do it after your first round of financing, and just make sure your seed's got enough, your Series A, when you get to that point, has enough capital in there to do this, particularly if you're in a space where it really, really matters. Software's kind of iffy. It depends. I've been talked out of a lot of things on filing on software. You got to be thoughtful about it. I mean, a lot of people come back to me like, look what we did. How'd you do it? It was an algorithm, so it's math. I'm like, that doesn't work. So it's just a lot of that.
Yeah, I would say budgeting for IP expense too, as you're thinking about fundraising. I've seen a lot of companies, and you've probably seen a ton of this, they dramatically underestimate how much it costs. So just being thoughtful of that as you're going into your financing round.
That makes sense. All right, so we now I would like to turn more to the transactional side. We talked a little about prosecution. When it comes to transactions like licensing or assigning IP, what kind of unique considerations are there in MedTech, and what are some other tips that you have for how to structure one of those transactional agreements?
Let's talk about most experience.
So transactional as it relates to IP. So this is kind of what I think Charlie made the comment. I've seen, or maybe it was Todd, I've seen lots and lots of pitch decks. And what's always, and whether it's, say, the Cleveland Clinic or a hospital system pitching to a potential licensee, or a startup company pitching to potential investors, it's surprising to me to see the range of disclosure about IP that you'll see in these pitch decks. Clearly, the more sophisticated, or I'll say more experienced, people that have been there, done that, people like Charlie, they know that that's like a really important piece of the message that you're communicating when you're trying to get to a transaction. So that's, and then, I mean, sometimes I'll see them in the little of you, like one bullet point in a slide that says provisional patent application filed, whatever, last week. And nothing else. Like, people have no idea what the claims are, they have no idea what the timelines are, so that's one of the key things is having, like, that important piece of information. Here's my IP, here are priority dates, here are key claims. If it's a pharma, is it composition of matter? Yes, they're going to want to know it's composition of matter. So you have to, when you're going into those discussions, whether it's whatever the transaction is, there are going to be a lot of questions, again, I mentioned before about the science and the clinical studies, whatever, but you got to be on top of it, and you got to know what IP you have, because that is a very key component of any transaction that's going to happen for that technology.
And as we think about the out-licensing piece of finding the right partner, well, part of it's understanding the partner. Well, first piece is understanding the value, which we talked about a little bit. So understanding the value of the IP, how it fits into the competitive environment, how this impacts the partner, the specific partner that you're talking to. Are they the optimal partner to get this out to the masses? Do they already have a sales channel to do that? All these sort of play into it. You'll oftentimes work with the partner to understand a forecast for what they think they can generate based on that product, and that kind of drives the value as well. I will work on one technology where we're talking to a Medtronic or something like that, and yesterday I had a technology and first-time CEO, the inventor is part of the team. There is no license or technology without the inventor, so that's a very different discussion. The only avenue to really commercialize that is to work with the inventor to launch the company, whereas some technologies, we can have multiple licensees depending on the field of use. So it really, really depends on the technology and the partner.
How about you, Charu? We can just go down the line. Any tips on engaging in sort of transactions to buy or sell or license IP?
I think again, same thing, like the story that I mentioned, my first transaction experience was a little bit of a disaster. Is really not really tipping it based on the business, like what is it that you're trying to do here? That's really important. The other part of it, one of the things I realized after my company was acquired by Medtronic is, and this is not uncommon for a lot of medical technology companies, is large companies incentivize their R&D teams to produce IP, and they actually get paid for inventions. Very different than startups who are trying to figure out how to pay for the invention that they have. I went into a team that had hundreds and hundreds of patents that would never be, probably it wouldn't be, implemented or it's worth patenting, but people were submitting. So the lawyers there looked at things so differently than what we had been used to. So, but from a transaction standpoint, that's what they come after. They're like, we've got 15 patents in this space, and let's see. And it's just a waste of time. Mm-hmm. So it's really important as you're working, especially if you're a startup IP counsel, it's a very different game than just corporate legal, IP counsel of a large company where the assets, and they're going to put money towards everything. Let's file across the globe, right? So there's that component of how, and they're going to be overlapping, right? We are in the same space. That's why they acquired us, because it made business sense. But the IP space was very, very messy, and we spent over 6 months sorting all of that out in terms of who belonged to what, which claims overlap, and things like that. So just a viewpoint as to understand what is out there so you're able to preempt that properly.
Makes sense. Charlie or Rich, any comments on that?
Yeah, getting back to my point about the data room, always be ready. So we've got several, even now, we've got several agreements where there is a revenue royalty in addition to a warrant around it. And it's because it's things we developed together, and it was a fair and right thing to do, and it keeps them motivated. But the challenge is that poison pill that you could accidentally take, which is related to somebody acquires you, and now it's a rev share on their revenue, which is which could be, or your product gets completely engulfed into something else. It's like, where's the revenue now? We found that we have to make that really clear early on in what the, whether it's a one-time fee or it's structured, in a certain way, but it can't be open-ended, because your acquirer is going to look at this and say, okay, we're going to devalue because we don't know. Or someone's going to have to work, they're going to tell you, hey, before we finalize this deal, fix this, and so.
You have to renegotiate under pressure, which is difficult.
Yeah, and then it's even worse. Yeah, exactly. So, not going to make that mistake again, but that's what I just said is super easier than done.
Mm-hmm. So always ID your royalty base. That's a definite. All right, we're running close.
I'd like to just build on something I think that Charu was hitting, and also from the prior conversation about comps. Yeah. And so the importance of knowing your comps and what those comps actually relate to, because people will be throwing out their comps, you have your comps, they have their comps, And that there is also an IP component to the comps. You might have someone say like, well, our comps show this, this, and this. Well, I know your comps, that IP only had, that was composition of matter, and that only had 10 years of life left on it. Or you had a comp and you're giving me comps and you're telling me it's for, maybe it is a composition of matter, but guess what? It's for a very specific molecule. I have a platform technology. So it's really, when someone starts throwing comps at you, is really understanding what your comps are in terms of when you're doing those financial terms on a license.
Any final comments from Rich? We're running a little bit close to the end of time, so I'll let you make the last remark, and then folks can ask questions after.
I was just thinking as Charlie's talking about that data room, and the IP is going into the data room, but before it goes in there, make sure that we, on the sell side are doing our homework. So make sure that, everything that you're uploading in there, you've got all your ducks in a row. You've got the assignments properly filed. You've got the powers of attorney, the prior arts in there, because the IP lawyers on the other side are going to do everything they can, even though that company or that investor wants to work with you, they want to devalue you, and they want to find out any landmines that are there. So they're going to dig into every little aspect of what you put in there and make sure that it's right. So don't put it in there unless you've done that homework and know that you've got all your T's crossed and your I's dotted.
All right. Well, thank you so much to our panel. We're running right at the end of time and about to start our next panel, so I'm going to switch right over. But if folks have questions for those on our panel, feel free to walk up and ask them. Thank you again.
Thank you.
And thank you so much to Tarolli for being a sponsor as well.